People versus Ballman. Counsel, would you like any rebuttal time?
About 5 minutes, Your Honor.
You have it. Go ahead.
I intend to address all the issues, including the issues raised by the respondent here in her opening brief, unless the Court wishes otherwise. The first issue, or the issue raised by the people here as the appellant, is the language in the newly enacted statute in 2006. And the purpose of the changing of the statute was to close loopholes, because previously persons who had been convicted out of state for driving while intoxicated would not be treated on equal footing with those in New York State who had prior convictions. And the problem, of course, is the wording of the statute and the enabling language made it unclear to those of us who were practicing what the word convictions referred to.
It was clear enough when it was first enacted in 1985, right, because it said out-of-state conviction.
Yes.
And then in 1988 the words out-of-state disappeared.
Correct.
And is that when the meaning changed?
Well, I think that the question is, the new statute, what was it intended to cover?
Well, let's stick with the 1988 statute for a minute. What do you say it meant?
I think it meant, a reasonable person would believe that it meant out-of-state convictions, because
even though they dropped the words out-of-state, it still meant the same thing.
I think it may have intended to mean that. I can't speak as to what
okay, but
people
but then in 2006, when they continue to use the word conviction without any modifying clause, either out-of-state or in-state, then you say then it meant in-state?
Well, I'm sorry. Let me back up. I think that when, based upon the rules of construction, that in 1988 when those words were dropped, that it was intended that those words be dropped, again, to give the statute the most teeth to cover as much.
So they dropped the words out-of-state in 1988, and you're saying by doing that, what they were doing really was changing the whole, referring to different convictions, referring to the New York conviction, not the out-of-state conviction, thereby putting no limit on the out-of-state conviction that you can use. No time limit, except the 10 years that everybody has.
Right. I think that based upon the rules of construction, that when it was omitted, we have to, at least looking back, I mean, that statute's no longer in effect, that they were presumed to omit it on purpose. But I think even if we were to find the other way, that it was simply an omission, the question then becomes in this 2006 statute, in dealing with the wording that they already had, and trying to fix whatever problems there were, that the wording that we have now does not use out-of-state convictions. So in using the rules of construction and
Don't we have a pretty good idea as to what deficiency they were trying to correct?
Yes, we do, actually. And it says the wording of the purpose in the memorandum is to ensure that a prior out-of-state conviction, not future out-of-state convictions from November 1st, but prior out-of-state convictions. So if they intended that all future
that could mean prior to the conviction for which the guy is being sentenced.
Well, yes, we would have to assume
prior conviction is frequently used to mean an event previous to the present conviction that enhances your sentence.
Yes, absolutely. But in this case, it's the clear stated intention of the legislature to close a loophole in the law which allowed large amounts of people to escape the penalties, the same penalties that someone in New York State would.
But how do we know that they didn't decide just to close it going forward and to leave the loophole in place up to the effective date of the new statute?
We don't know for sure. We have to rely on what their stated purpose was, which was to close the loopholes. That's
well,
the problem.
we also look at the specific language of the sections. And looking at the effective date section, it begins with the clause, the provisions of subdivision 8 of section 1192.
Right.
And when you look at subdivision 8, the first sentence is effective prior out-of-state conviction.
Right.
So aren't they incorporating by reference?
Yes, but what the effect of the prior out-of-state conviction on the present conviction, what is it affecting but the present conviction? So I see what you're saying. I thought about that myself. If they're just using conviction as to the prior, but to finish that sentence is the effect of the prior conviction on the now New York State conviction. So you're not talking about effect on our actions or the crime. It's the effect on the conviction, which would be the new conviction.
Well, they could have clarified that. I mean, there
there
has to be a reason they put that first sentence at the beginning of Section 8.
I think that.
Because that's all that provision deals with.
Right. But it's talking about specifically.
So the effective date section says the provisions of subdivision 8.
Right.
So it seems to me to be encompassing only out-of-state convictions.
I see what you're saying, but I still think that the effect of the prior out-of-state convictions will apply to convictions after November 1st. We're talking about the effect of that conviction on the new conviction. The effective date would be November 1st of 2006. I seem to be confusing, but.
No, I understand what you're saying. You're trying to rely on legislative intent, but we generally would look at the statutory language first.
I'm trying to do that, but I don't think I'm making myself clear.
Well, it's a little bit confusing. One of the things that struck me is that it used the word convictions, and if you're going to charge somebody, you don't know. I mean, it can't apply to convictions, meaning in-state convictions, because they don't happen until later. I mean, if you want to charge somebody with a felony, saying they've got an out-of-state DWI under the new ones, you got to charge them with that. You can't wait until the conviction and then say, well, now that he's been convicted of a DWI in the state of New York, he has a prior conviction out of state, and therefore this conviction becomes a felony. Because you have to charge it as a felony in order to convict him as a felony, right?
Right. But I think that the way this is worded was poorly worded, obviously. But if you're going to give it the meaning of the words that are in there, that it would have to apply, saying the same thing again, but it would have to apply to the conviction now. And we're talking about a situation where we're talking about enhanced penalties, so the conviction itself is the operative point in time. If you're just charging someone, what the relevant fact is, in fact, the conviction, and what the sentence will be. It's the same underlying act, so to speak. So what's relevant is the conviction, not the charging. The charging is really the same, but for the fact that the indictment says as a felony. So it leads us to go that extra step and file the special information, but it's not relevant until the person is convicted, and that's why I think the word conviction is important. So while charging is part of it, it's not the only inquiry.
Well, doesn't that prior conviction have to be proven to jury? You're not suggesting that it's only relevant post-conviction in order to enhance the sentence.
No, it has to be proven, absolutely, but it becomes relevant once the person is convicted after it's proven or admitted by the defendant outside the presence of the jury. So that's why the word convictions is so important. It's not just the charging, but the actual conviction that would be affected by it. There was some argument about the ex post facto nature. I just want to address that very quickly. That when someone's making a facial challenge to the constitutionality of a statute, they bear a substantial burden, since the challenger must usually establish that no set of circumstances exist under which the act.
You can see that on your reading there will be cases where the statute is unconstitutional as applied.
I think under either reading, because a person could have committed the out-of-state acts before November 1st, 2006, but not be convicted until after that effective date.
Well, this is a 1999 Georgia conviction.
Right.
That you're using to bump up.
That's right. But I'm just talking hypothetically with regard to ex post facto.
Well, yeah, but I guess I have the same problem Judge Saparic has. You're not saying it's unconstitutional. You're not conceding it's unconstitutional to apply this statute to out-of-state convictions that existed when the statute was enacted.
No, I'm not saying it's unconstitutional at all. I'm just saying the fact that it can be applied to some class of persons violative of the ex post facto clause does not make the whole statute violate the clause.
How is there explain to me how there could be an ex post facto violation on your adversary's reading of the statute?
I don't know that there could be. If I were to draft the statute, I would have drafted it in such a way that it would not. But the fact that it does to some class of persons does not make the whole statute, does not strike the whole statute down. And I think, the rules of constitutional construction are clear on that. Anytime you have something which might, even with violent felony offenses, it might affect someone later on differently than another person, you can apply it in such a way that it might be ex post facto, but that doesn't mean that the whole statute should be struck down.
Okay, counsel. Thank you.
To please the Court, ironically, when they enacted this legislation initially in 1985, they used the same close the loophole language. And it was offered with, let's make convictions from another state be treated like driving while impaired here. And from the very beginning, it said, but we're not going to count convictions in another state that happened before this law took effect here. In 1988, although they changed the language, there's nothing to indicate that they were intended to change the statute. They revamped DWI completely. Legislative history just shows that this was intended to carry over.
In hindsight, it was not such a great idea for them to drop the words out of state in 1988.
Right. And the only explanation or the only thing that salvages that is using November 29th of 1985, because you can tell from that that they have to be looking at prior out-of-state convictions. And
by using the 1985 date, you draw the inference that they meant the same thing that they had meant in 1985.
right. And with respect to this statute, why would there be Provision 2 of the enabling language when you have Provision 3? Provision 3 says this takes effect November 1st, 2006, like every other statute. So if we were going to consider every prior DWI from another state as a DWI here, because it occurred before November 1st of 2006, why would we need a provision that says, but by the way, don't count crimes that happened before 1985 and things that happened between 85 and October 31st of 2006, treat only as impaired? The only reason to put that in there is to carry forward what they started with in 1985, which is our citizens will not be held to account for change in our law affecting what happened in another state until our law takes effect prospectively. And again, the policy reason for that, if you're in Florida and you have a DWI charge and you have to travel back there to keep dealing with it, you may make a decision about that DWI you would not make if you thought it was going to cause a felony conviction at some point here in the future. Now, and I submit the Fourth Department's decision following the legislative history, looking at the language, tells you the legislative intent, because you're tracking, as the court said in Lido, you are following the course of the legislation to determine their intent. And their intent was to do what they've done all along. If, however, you decided otherwise, the appellate division did not have to deal with the issue of whether this is an equivalent DWI. And the Commissioner of Motor Vehicles did not like this statute for that very reason, that you have to then compare elements in the two states.
Would we have to send it back for a comparison of the elements?
I'm sorry.
Would we have to send it back for a comparison of the elements?
You could, but here it's clear because the one case cited by the people, the Latterulo case, is looking at our DWI paragraph 3, being too drunk to drive. The provision the defendant was convicted of is a blood alcohol content. If you look at blood alcohol content, the two Georgia cases, Allen and Yarburg, make clear that their test has to be within 3 hours of driving, and if you blow too high within 3 hours, your DWI in Georgia, regardless of what you were at driving.
So you're saying that it's possible to be convicted of this crime in Georgia even if you're innocent under New York law?
Yes.
Assuming there's one such case or a few such cases, does that do it? Does that mean you can't count the Georgia conviction?
I think that if their law is not like ours, I mean,
Does it have to be does it have to be totally congruent with ours? If it reaches one person that ours doesn't reach, does that mean you throw out the whole statute for predicate purposes?
I think you do what we've been doing for or for felonies and second felony offenders for years. You look at their statutory language, you look at our statutory language. If the two are different and...
Yeah, but I'm trying to, I think you're not answering, how do they have to be exactly the same, or is there a point at which they're close enough?
No, they don't have to be exactly the same. Like they're driving under the influence, where the Laterulo case was talking about, we could compare it to our driving while intoxicated 3, and you could find by case law that...
Even though it's imaginable that there might be somebody who would be convicted under theirs and acquitted under ours?
Yes, conceivably. But here, under Mertz and Alvarez, we look at drunk driving at the time of operation. You don't look at the BAC 2 hours later to see whether you were drunk 2 hours later. You use it to find out whether you were drunk
But
at
in
the
the
time
vast
of
majority of cases, that's going to get the same result, right? I mean, if you show a high blood level alcohol content 2 hours after driving, the inference that you were drunk when you were driving, pretty compelling.
Yes. But in Georgia, you can have a BAC 3 hours later that's higher than the limit, and that's still drunk driving even though you were lower at the time. Here, we can prove that you were lower by bringing in evidence experts when you consumed what you had to eat to try and show you weren't drunk at the time. And so that makes this statute in New York State and this statute in Georgia not equivalent. The statute he was convicted of. And so even if it was a situation where this law applied to a 1999 out-of-state conviction, made it a misdemeanor, it would not apply in this case. Now, with respect to the issue which we're appealing, I submit that this is not an appropriate investigatory detention. In Hicks...
Why is that not a mixed question?
Because both courts found that there was probable cause for arrest after the field sobriety test. Both courts looked at what happened before that and apparently found no probable cause, or they would not have found that there was probable cause after the field sobriety test. This court can determine what is an investigatory detention, as you did in Ryan. You looked at what the facts were in that case and said, this is not what an investigatory detention is.
Well, does every application of that definition present a question of law? I mean, if the appellate division says, I think this fits the test the Court of Appeals has set down, has set down, they quote the test correctly, but we might apply it differently, is that a mixed question, or is that a pure question of law?
I think it's a question of law whether it constitutes an investigatory detention. You can't go back and look at the facts. They found the facts of what happened.
What takes it out of the realm of mixed question jurisprudence?
Because in Hicks, you created an investigatory detention Terry-like body of law, and the line has to be drawn. That, as the court said clearly there, this is hard because every situation is different. We don't want to fix a bright line. You gave us 4 factors to look at, 2 of which aren't here. That being that we know a crime has been committed. Here, they didn't know a crime had been committed when they handcuffed him and took him back to the police station. And of course, with DWI, you have to be very careful because we can't talk about driving while impaired. It's a traffic infraction. The requirement of reasonable suspicion is that a misdemeanor or felony has been committed, not that a traffic infraction has been committed. And of course, under normal circumstances, you have a stop, you have a traffic infraction, or you wouldn't be stopped. So there's been probable cause to believe something.
Are you saying that if a driver appears tipsy, you can't tell whether he's impaired or drunk, whether he's in subsection 1 or the other subsection, that you're not allowed to detain him to find out?
You have a right to inquire, and you have if you've already stopped him for something, you have probable cause to believe a traffic infraction has been committed, and you can hold him there to keep doing the ticket.
And if he runs away, can you chase him and bring him back?
because you have to issue him a ticket, yes. The more difficult situation is...
You're saying the difference here is there was no traffic infraction?
Right. If a police officer approached a stopped car and said, give me your driver's license, goes back to the car to get the driver's license, and smelled alcohol, the guy gets out of the car. He didn't stop him. He approaches a car already stopped, like happens all the time. And the driver gets out of the car and runs. There has been...
Even though the officer smelled alcohol. So if I, the car is parked. The officer walks over, says good morning, and while he's saying good morning, smells alcohol in his breath, says, would you mind if I give you a field sobriety test? The driver speeds off. Or doesn't speed off, drives off under the speed limit. He can do that. You're saying that's okay?
The driving is a different problem, but...
You mean you can run away but you can't drive away?
If he didn't commit a traffic infraction,
He hasn't done anything except there's liquor on his breath.
Right.
So
The police officer...
So he can say, sorry, the light's green, officer, when the officer says, have a nice day. That's what the officer's got to do? Doesn't seem reasonable.
He can follow him. He can follow him. And it takes a crime to have reasonable suspicion to pursue and detain someone. If that person stopped along the road, ran away, and the police officer followed him, caught him, could he then handcuff him and drive him to the police station? Even if he were down the street, could he take him into the police station to do field sobriety tests? And isn't that the situation we have here? That this police officer could have done field sobriety tests? You handcuff him, you got 2 police officers there, you calm him down, and then on the street, do field sobriety tests here. Let me determine, like I always do, whether or not you were driving drunk when you came to the police station. And he didn't do that. They handcuffed him and they drove him back to the police station. And you can't use the explanation that there's another person in the building. That person was getting an appearance ticket. That was the whole point of Mr. Ballman coming. And there are now 2 police officers. So one could easily have gone back to the police station and dealt with the person who's still standing in the lobby when they get back.
Let me see if I'm following. You're saying when the guy ran away, it's okay to go after him and grab him, but not to bring him back?
Once they grabbed him, ran him down, escorted him to the ground, handcuffed him, escorted him back up, put him in a police car, don't tell him, by the way, because in Hicks...
At what point were they violating the law? They're allowed to run after him. It's a free country. Are they allowed to tackle him as he's running?
Well, then there's clearly a seizure at that point. And I would submit that there's not reasonable suspicion at that point to believe a crime had been committed. Maybe there was reasonable suspicion to believe that driving while impaired had happened, but not DWI at that point. But clearly, once they take him into the police car, drive him back to the police station, he is in custody. A reasonable, innocent person at that point would believe they're not free to leave. In Hicks, the court was very...
Well, everybody in an investigative detention is not free to leave.
No, but in Hicks, the court was very careful to say that those men were told, we're taking you over there. If he doesn't identify you, then you're going to go. They weren't handcuffed. There's nothing here to show that the police officer said, look, I'm just taking you back to the police station. We'll do the field sobriety tests. If you pass them, we'll let you go. So, and it is the Yuckle standard that's used to determine when an investigatory detention swings over to an arrest and you needed probable cause. And I submit that the investigatory detention can't swallow the rule of probable cause. If this is a situation where an investigatory detention, where you can take a person back in handcuffs to the police station forcibly, then investigatory detention can be almost boundless, up to the point where it's Ricky Ryan, where you're just sitting there in a police car waiting for somebody to identify you and you don't really need the guy to start with. That's one extreme, Hicks is the other extreme, and this is one of the tough cases in the middle, and I submit the court needs to establish rules that give police officers and trial courts greater distinction in terms of where it's appropriate and where it's not. Okay, thank you.
Okay.
I'll address point 2, which deals with the respondents, that the underlying conduct must have constituted a misdemeanor or felony in violation of any of the provisions of Section 1192, which is what the statute says. It's the underlying conduct which must have constituted a misdemeanor or felony. So it's different from the Penal Law Article 70, which talks about the elements of the statute. Although this is a jurisdictional issue and can be reached by the court, I do believe that it should be sent back to the county court if it reaches this issue. I don't think there's a sufficient record to determine whether the conduct with which the defendant, how he committed the prior crime in Georgia, violated what the underlying conduct was.
You're saying it's the conduct that has to match, not the statute?
That's my reading of the
And
details.
the statutes obviously have to have some overlap. I mean, if he committed conduct that would amount to drunk driving in New York, but he was prosecuted in Georgia for making an illegal left turn, that wouldn't be a prior.
No, I think we're talking about in the context of driving while intoxicated specifically, and I would agree that it would have to be for that. But because I think each state has different statutes, you have to look to the underlying conduct to determine whether it would be a misdemeanor or felony here. And of most significance, Your Honors, as I said, the record here shows that the defendant pled guilty to page 8 and 9 of the record says he pled guilty to count 2, but the actual admission signed by the defendant says that he pled guilty to count 1, and that was driving under the influence of alcohol. None of those things were fleshed out at the court below, and it wasn't preserved. In fact, the defendant sort of abandoned that
Who gets the
argument.
benefit of the doubt on that when there's an inconsistency in the out-of-state record?
I think it has to be looked at in terms of
So you say it's not for us to look at. So the trial judge looks at it, he says, I don't have the slightest idea. Who wins?
the defendant would win. I think it's really the people's burden to establish that, and we don't know whether it was established here or not. That's the issue that I think would have to go back for decision on that. And just briefly with regard to the search and seizure issue, I think that the police officer only had limited things that he could do at that point when he's faced with a person who may have driven to the police station in an intoxicated condition. He was the only one in the police station at the time, and he didn't handcuff the defendant immediately. He asked him, he put him in a room and said, I will come back and further my investigation. And the defendant then raised the level by the police officer was tending to something else. He went to make a phone call, and he saw the defendant. He was on the second floor and saw the defendant acting strangely, walking back and forth, and he actually told the defendant, don't leave, and the defendant fled. So this is not a situation where we just have the defendant fleeing and a police officer chasing. The police officer had reasonable suspicion based upon his observations to continue his investigation. The defendant then chose to flee, and like in People v. Galloway.
Do you say there was reasonable suspicion that a misdemeanor or felony had been committed?
Reasonable suspicion to believe that a misdemeanor or felony may have been committed. Correct.
Did anyone find that below?
I believe they found that the investigative detention was proper based upon that specific finding. I don't believe so, Judge. I think it was the way it was decided was that the investigatory detention was reasonable in light of the police officer's observations and the defendant fleeing as well. So that in that context, he's not fleeing. It would be reasonable to detain him for further investigation. Thank you.
Thank you.